The challenge that we have today, and I think some of the challenges that Josh Hawley was talking about within his article, is that Section 230 has been really broadly interpreted, specifically C1. So if we remember, C1 is like the broad product liability immunity from any lawsuits that platforms could be hit against for anything that gets posted online. The challenge that we have, though, is that now it's been almost 30 years, and platforms like Facebook, which wasn't even created or thought of by 1996, have developed all these new features that just we couldn't have any conception for 30 years ago. Now there are things like algorithms that boost up certain types of information and rank it as good or bad, or maybe something that's advertising potential or maybe not advertising potential. We have different design features like infinite scroll that really encourage you to keep and stay on the platforms longer, and just different design features and functions that these platforms argue are really good. The problem, though, is that also means that then platforms are making decisions about what kind of content gets upranked or downranked. And yet, in spite of that, because of Section 230's broad interpretation, they're still having that legal immunity up. So if there's some kind of problem that happens, and there's been a number of cases like this, where a design feature leads to mental health harms or eating disorders, or in really awful cases, a teen suicide, platforms are totally immunized for that because that 30-year-old law says, hey, as long as platforms are staying neutral and unbiased, then they can have immunity. In reality, though, we've seen that these design functions mean that platforms and companies aren't actually being neutral when they're talking about different content.